may. So we will proceed to the second matter. Albert Bryan Jr. in his official capacity and the government of the Virgin Islands versus the Water and Power Authority. That's number 14 of 2023. Council, you ready to proceed? Okay. You wish to reserve any time for rebuttal?
5 minutes, Your Honor.
Very well.
May it please the Court, Deputy Attorney General Ian Clement, on behalf of the appellants. The separation of powers doctrine requires a balance between the authority of the three coordinated branches of government. In this case, there must be a balance between the legislature and the executive. Here, the balance has tipped too far in favor of the legislature, such that the separation of powers doctrine has been violated. The Court here must examine the extent of the intrusion into the duties of the subject branch, whether the intrusion is justified by an overriding need to promote the objectives of the Act, and finally, it must examine the extent to which the intrusion prevents the subject branch from accomplishing its constitutionally assigned functions. Act 8472 violates the separation of powers doctrine because, one, the legislature improperly intruded into the authority of the governor to appoint or remove WAPA board members. Two, that intrusion was not justified. And three, the intrusion hampers the governor's ability to manage and supervise the board as is required under sections 11 and 16B of the Revised Organic Act.
Pardon me, supervise which board? Say that again. You said something about supervising a board?
Supervise the WAPA board?
Yeah. Is that what you're saying? Yes. Are you suggesting that somehow the governor has the authority to supervise the WAPA board?
Part of his function to supervise all executive branches, agencies.
Hold on just one cotton picking minute. Look at what it says here, because look at what it says here in section 16 of the Revised Organic Act. All right? Because this is the key right here. It says the governor shall, within 1 year after the date of approval of this act, reorganize and consolidate the existing executive departments, bureaus, independent board, agencies, authorities, commission, and other instrumentalities of the government of the Virgin Islands. All right. When they are talking here about the governor reorganizing independent board, they're talking about independent board that is under the auspices of the executive branch. When you drop down into subsection B, look at what it says. The governor shall from time to time, after complying with the provision of the subsection A of this section, examine the organization of the executive branch of the government of the Virgin Islands. So that A and B, when read together, it's all about boards, independent or otherwise, under the executive branch. Can anyone really suggest that WAPA is under the auspices of the executive branch of the government of the Virgin Islands?
Yes, it is under the executive
How
branch.
could that be? Pull out section 103. Do you have the sections that deal with WAPA? Because we have to go through this. This is very important, very important. It says here, there's hereby created a body corporate and politic constituting a public corporation and autonomous governmental instrumentality of the government of Virgin Islands by the name of the Virgin Islands Water and Power Authority. It's an autonomous body. Down below, it says that there's hereby created and shall be an autonomous governmental instrumentality provided here in controlled by the governing board. But it is a corporation having legal existence and personality, separate and apart from the government. So WAPA board is a legal existing and personality separate and apart from the government of Virgin Islands. The the board are the policy maker of WAPA, not the governor or the executive branch. But there is more. Here it is, it says that the WAPA has the right to enter into debts and obligations and contracts, notes and expenditures and accounts and facilities and property, and shall be deemed to be those of said authority and not those of the government of the Virgin Islands. The debts of the government of the Virgin Islands is not the debt of WAPA, and vice versa, because what was created was really something that I don't know if they really intended to do so. Remember now, the policy maker of WAPA is what? The board, not the governor. Go on to 105 of the power of the authority. It said to have perpetual existence as a corporation. What is a corporation? Then it says that to alter, adapt, and use a corporate seal and shall be judicially noticed. WAPA has its own corporate seal, and from time to time modify and repeal its bylaws, rules, and regulation not inconsistent with this chapter. So the WAPA board is the one that really controls everything. Now, here it is that WAPA can be sued and be sued in its corporate name, separate and apart from the government. It's a corporation that can be sued and be sued in its own corporate name. And then later on it says that it shall acquire property, real, personal, mixed or tangible or intangible, and it goes on to say, matter of fact, WAPA can even enter into contract with the government of the Virgin Islands. Am I correct?
Yes, Your Honor.
All right. So how can the governor control a board when in fact that he may be entering into contract with that same board, and he gonna control the board at the negotiating process? Then he can dictate to the board what to put in that contract. But hold on, it doesn't stop there. WAPA has a right to borrow money and make and issue bonds. It issue bonds. Its own bonds separate and apart from the government of the Virgin Islands. I mean, this is really something. And it can accept grant or loans and enter into contracts, leases, agreements, or other transactions with any federal agency and the government of the Virgin Islands. WAPA can enter into contract, leases, and agreements and transactions with the government of the Virgin Islands. How is the governor going to be head of the executive branch, which he is, and still he's going to be, when WAPA has to enter into lease and contracts and agreements with the government, which it is authorized to do, wouldn't he not have a conflict of interest?
Your Honor, the court below.
Well, hold on now. I'm not finished yet. I'm not finished yet.
But just to, I know that you're going.
Yeah, I know he is edging, but I need
But
to
I
get
know
my
I know
lumps
he
in when
wants
I
to
can.
tell us that this court has ruled that public corporations such as WAPA are considered to be part of the executive branch. So I know you're gonna jump at us.
Yeah,
And that was in the
he's-
VI Taxi versus West Indian Company.
Exactly, Your Honor.
So,
And, you know, and the thing about it is that where does WAPA gets its money from?
most of it comes from the government now.
Yes, it comes from the government.
Well,
Anyway, but let me just ask you this, because, you know, your time is already up already. How does, you know, the change in the board interferes with the governor's right of appointment and removal, as you say, that's your first point?
So you have to look at the purpose of the act. So the purpose of this particular act was, the stated purpose was to create this board of experts. But what they did was remove two cabinet members from the board. And these cabinet members are the people who are most experienced in engineering and finance and procurement and federal grants and public works. So to say that you want to create a board of experts, but then you remove two people, two positions that fulfill those requirements, whether it be experience, whether it be education, it undercuts your stated purpose.
But is replacing them with specific qualifications?
Well, not
So how does that, just tell me, how does it interfere with his appointment powers?
well, right,
The
because
fact
it's,
that two of his cabinet members are no longer on the board?
well, because
Particularly when he retains the right to appoint every single member of that board.
it's true, but he cannot remove the private sector members but for cause. And that is a serious standard to make. We're talking about malfeasance, misfeasance, or nonfeasance. You have to initiate a proceeding.
Well, I'm sorry, where are you finding that definition of for cause? Where are you getting that from?
I'm getting that from Centeno versus King, 14 VI 168, Jump Site 179, Territorial Court, 1977. So we're dealing with a serious,
who removed members of the board for cause? Isn't it the board?
Governor can.
The governor.
right, so the governor can remove them for cause, but unlike the members of
But
his
isn't that an
cabinet.
exception that's allowed?
Pardon?
Isn't that allowed?
It is allowed, but hear me out. So when you have individuals who are members of his cabinet who serve at his pleasure, right?
It's easier. I mean, of course it's easier. He can just remove a cabinet member who he feels is not carrying out his policy, carrying out the board's policies, or it's simple, just replace him with another cabinet member. That's easy. However, how does this change? The question is, how does this change prevent the executive from carrying out its statutory duties?
Because it removes his flexibility. So it's not just dealing with a board member, a cabinet member who's not doing his job. It may be, in this particular instance, we need someone from Public Works. In another particular instance, we need someone who is versed in energy
And what is
production.
to prevent the board from requesting assistance from the Department of Public Works, the Department of Property and Procurement? What is to prevent the board from doing that?
They can't do that. But Your Honor, the problem here is that if your stated purpose is to create these board of experts, and the only reason that you're removing two of the governor's appointees is because they're government appointees, that is a violation of the separation of powers doctrine. You are now interfering.
I'm
Well,
sorry,
one
what is
thing-
your argument there? Because
Well, if your stated purpose is to create this board of experts, right? And these experts, these appointed people who are appointed by the governor, who have already been vetted by the legislature when they got their appointments in the first place, are already experts. So you're removing these individuals or these positions from the board.
How do you know that they are experts? The governor can select someone strictly for political reasons and,
Because they're vetted by the legislature. They go before the legislature and they are approved. So they've already been
But they
vetted
have-
in the
I'm
first
sorry,
place.
I am really missing a lot from this argument, I think. The question is, how do you know they are experts? And your answer is because they go before the legislature? I'm missing something here.
Well, these individuals are experienced. You don't get to be the commissioner or director or commissioner of property procurement or director of public works unless you have experience in those particular instances.
Yeah, but there's a whole lot of people
That's
here
not-
that
but-
are architects, engineers, CPAs, tax expert, lawyers, everybody. Not only cabinet members have this qualification, and if you name somebody that's a non-cabinet member, they have to go before the legislature anyway. But the Commissioner of Property and Procurement is not the one or the only person in the territory conversant in what we call in contracting and acquiring property. The Commissioner of Public Works is not the only one with an engineering degree in the Virgin Islands. So you do not necessarily have to be a cabinet member. It just makes it perhaps easier for him to remove them. But for all intents and purposes, you got architects and engineers and tax expert, real estate expert, lawyers, attorneys, everybody in the Virgin Islands with all kind of discipline that can sit on that board of WAPA other than cabinet members. Cabinet members do not have anything special that says that more credential than anybody else.
Well,
Similarly situated that is licensed. You know, you got to be a licensed architect, a licensed engineer, a CPA, you got to sit the exam, a real estate expert, and evaluation of property. All of these people are out there in the private sector. It's easier for him to control the board if his cabinet members are on it.
well, yes, and what we're saying is that they've placed a substantial burden in path of the governor's ability to manage and supervise the board. And the governor or the appellants don't argue with placing qualifications for all the board members, whether it be the private sector members or the problem that we have here. First of all, when you directly say that the director of the energy office is the only government appointee who can sit on the board, that means that if the governor does not agree with what he does on the board, the only way that he can replace that person on the board is to dismiss the director of the energy office altogether, because the director of the energy office is the only government employee who can sit on the board. So he would have to replace that person altogether from his post and then get another director of the energy office.
How does that make it inorganic or unconstitutional?
Because they've now gotten involved in directly appointing a member of his cabinet versus allowing the governor under the proviso.
Did the act name the person, or did the act name the office?
Name the office, but now if the governor wants to remove him from the board or her from the board, he has to dismiss that person from his post altogether, because the only cabinet member who can sit is the director of the energy office. So in order to remove that person from the board, because you're not going to have two directors of the energy office, you're only going to have one. So if you want to remove him from the board, you have to dismiss him from his post, appoint a new director of the energy office who would then sit on the board. That's a violation of the separation of powers doctrine. Now you're getting involved in the appointment of a cabinet member, when this part of his job is only part of his job. It's not his entire job.
All right, well, let me ask you this. Suppose we just say no cabinet member, the governor will have the appointing authority for all members of the board, right? All 9 members. But we're not going to make sure that any cabinet member, we don't have to have cabinet members on the board. Are you saying that is going to somehow be a separation of power issue?
Well,
No.
Historically, the governor or the executive branch has had a direct involvement in the board. So in 1964, it was the governor and the commissioner of
But
public
time
works,
has changed.
right? And then it was then he was the director
So
of.
why not give him the
But-
full compendium
sorry.
of authority to appoint anybody that's qualified for those spots? They don't necessarily have to be a cabinet member, but if he wants to make it a cabinet member, then that's it.
It
Yeah,
takes
yeah.
it takes away the flexibility of the governor to manage the board because he has the
You see, and
flexibility.
that's the key there. That is the key. He wants to manage the board, but the legislation says that the policy-making body of WAPA is the WAPA board, not the governor.
But the Revised Organic Act says the governor, from time to time, after complying with the provisions of subsection A of this section, examine the organization of the executive branch of government of the Virgin Islands and shall make such changes therein, subject to the approval of the legislature.
Right,
not-
right. I understand what you were saying, but you started with the premise that somehow WAPA is part and parcel of the executive branch.
The court has said that.
But it is not, because, WAPA, according to Mr. Hodge, when his testimony before the legislature, he says, we get our source of money for WAPA from two places. One, from the rates, the customers,
Right.
the customers that pay us. And who determine those rates? Well, we have to go before the Public Service Commission, who tell us that rate. And the second big thing in terms of the money comes from us floating bonds and getting money to finance WAPA. That is why we meet every 4 months with Fisk and Moody, who are bond people in the conversing in the bonding business. So for all now, that's not to say that sometimes when WAPA is running short of money, that they wouldn't try to ask the governor for see what you can do, governor, to help us out, because you know why the governor and the legislature would always help out WAPA? Because it would be catastrophic, and it affects everybody on this island to have that electricity flowing. That is why. But coming back to the principle, who controls WAPA? Well, they have a board. Board members are the policy makers. They get their money not necessarily for the government of Virgin Islands. That's not to say that from time to time the legislature and the governor wouldn't get together and help out WAPA by a little loan here, a little loan there, a little loan everywhere. But first and foremost is the bond and the rates that they charge customers like you and me. That's where they get their money from. So this is not really an issue of separation of power or anything. This is the issue of who should control the WAPA board.
I have a quick question with regard to the for-cause provision, that removal limitation regarding the board. That was not part of the legislature's amendment in Act 8472, the for-cause provision. Has not that provision been there,
Yes,
existed there since 1984?
Exactly. That has been there. But when you remove the two executive branch members from the board, and now you only have the energy office director, and it makes the for-cause
Let me see
provision.
if I understand what you're telling me.
Right. So it makes that for-cause provision more critical, because when you need a quorum of 5 and you have 3, because they're going to show up, the cabinet members are going to show up. You just need 2 more of the private sector members to be there for quorum. It's a lot easier to deal with.
See, I don't understand that argument,
It's
though.
constitutional. It's constitutional then. If you have 3 members, 3 cabinet members on the board, it's constitutional. But if you have only 1 cabinet member on the board, it is not constitutional and inorganic.
No, I'm not saying that. What I'm saying is that it makes it
So it's
more difficult.
Sorry, just a minute. It's not constitutional, period.
I'm not saying that, Your Honor. I'm saying from a practical. Let's take for example. Recently there was a vote for the underwater.
We understand that, but doesn't this make it easier to make a quorum? Instead of a quorum being 5, now it's 4, right?
Well, that was not in the body of the act. That was not included in the body of the act. I mean, they're operating that way, and that was assumed by the lower court, but that is not in the body of the act. So We're dealing with, you know,
But anyway, you know that, you need a majority for a quorum. And, you couldn't make it because you needed 5. And if it was 4 instead, as it is now under the new law, it'll be easier to make a quorum. So when you spend all this time arguing that it makes it so difficult, it seems to me like you're trying to pull at straws to somehow justify, the argument. And if, which I believe you will concede, that adding the for cause provision is allowed under Supreme Court cases and has never been an issue before. As a matter of fact, you talked about the hospital, Bryan versus the Hospital and Health Facilities Co-op, and there was a provision for cause, and they removed that, and the court ruled that interfered with the governor's right. He couldn't remove them for any reason, but the for cause provision was acceptable, correct?
yeah, in and of itself, a for
So
cause.
then, if I understand your argument, really, the only thing that seems to have any real merit to it is that by designating governor's cabinet officer, the energy director, as the chair of the board, that somehow that is circumscribing who the governor can appoint to that position, and it puts a duty and a task on the governor's commissioner or director that may be incompatible with his job.
It's all encompassing, Your Honor. So there is that point. That's the main, the first point. The second point is the removal of the 2 cabinet positions. Then when you
You're telling
couple
me
that,
the legislature cannot reorganize the board and add and remove members without violating the Constitution?
yes, but you have to look at whether the intrusion is justified by an overriding need to promote the objectives of the act. So the
But here obviously was, since the legislature override the governor's veto of it, and it became law. So obviously, it's a legislative act, and certainly the legislature created WAPA, created a board, and can get rid of it or can reorganize it in the way it wants.
Well, it has to have, in order for the separation of powers to work, you have to have limits on each branch. So the governor has limits as to who he can appoint based upon the legislature's prescription as to the education and experience. But at the same time, the legislature has limits because once it creates a board, the power to appoint and remove is vested in the governor. And in this particular case, their removal of these 2 positions was really...
But it's done by act of the legislature. So it's the legislature's grace that is giving him this authority. And you're saying that the legislature can never change? And I guess that's one of your arguments, because it's been 45 years the same way, that somehow changing it is a violation of the separation of powers?
No, but what I'm saying, in this particular case, it was a pretext to remove the power of the governor. If you look at what the governor said, what the legislator said, for example, Senator Ginners talked about...
So, I'm sorry, you're saying that because, well, I understand how the government is interpreting those statements by 2 or 3 legislators.
Yes.
However, are you saying that the motivation of those 2 or 3 senators is more important than the stated purpose of the act itself?
Well, you take the stated purpose and you take those statements and you look at the individuals or the offices that they've removed, and theoretically these individuals who are in these cabinet positions, who are engineers or whatever, have already have these qualifications. And then you're removing these positions only because they happen to be appointees of the government.
But first of all, the governor doesn't have to appoint the property and procurement or the IRB. He can appoint any one of his commissioners to the board, right?
That's the entire point, because he has flexibility when needed. He can appoint the energy office director when he needs it. He can appoint the
So he could
commissioner of
appoint-
finance when he needs it.
You could appoint a commissioner of agriculture who have no experience and thing, and that would be a board member, correct?
You have to trust the governor to do what is proper, but theoretically, he could do that. But would he do that? No. So,
All right, in the legislation, it talks about having experts, such as somebody from the IRB, conversant in taxes. You talk about the procurement, so you want the Commissioner of Property and Procurement that have something to offer. You talk about the Department of Public Works, who is an architect or most times an engineer, most times a civil engineer and all these things. What would happen if the legislature gets up one day and said, you know what, we're gonna cut all of this out. The governor would have the authority to appoint members of the board, but we're gonna suppose, he has to appoint people with this kind of expertise, not necessarily cabinet members. Would that in any way violate the separation of power principle, where he will be appointing members of the board with advice and consent of the Senate, and then let the board determine who shall be the chairperson of the board, and then the board can go along and makes its own policy, so that and give the board the removal authority to remove members of the board. But isn't this nothing more than what we would say, actually, where the power lies?
well, Your Honor.
Control and power. That's all it's about.
Well, Your Honor, I mean, there's what could happen in theory and what happens practically. And I'm going to refer back to the instance of the extension and authorization of the contract for the underwater power cable for Cruz Bay. All right, that vote was almost missed because they couldn't form a quorum with the private sector members. I mean, these are the types of issues that you have from a practical standpoint.
Suppose everybody become a private sector person, and we get the government commissioners out of the fray of being board members. And the governor would have the authority to appoint members of the board with advice of consent of the legislature, but he should appoint people with these type of expertise that we wanted on the board. Would that in any way violate anything on separation of power principle? I can understand that what you were saying that, all right, since the new law calls for the chairperson of the board to be the director of energy, am I correct?
Yes.
And if I want to fire the director of energy, then it's gonna somehow hinder me because we need him on the board. But if you don't have any cabinet members at all, you just go to the private sector where you got architects, engineers, tax experts, financial experts, people in real estate that are experts, builders and contractors, people that have been doing procurement for in the private sector for large corporation companies and so forth and so on. Would that be a violation of the separation of power principle?
No, in theory, no, Your Honor. But what we're dealing with is
You see, once you cling tenaciously to this point, in fact, that since these commissioners already have been vetted by the Senate, and since they have this background and expertise, what I'm simply saying is that they are not the only one in the territory that have these expertise that you're looking for to put on the WAPA board.
Attorney Clement, let me ask you this. And giving the governor sole control of the chairman of the board, isn't that really giving the governor all the control he needs? I mean, the chairman of the board is going to set the meetings, is going to lead it, and here he is the only person who can appoint that. Isn't that really significant?
it's an intrusion into his powers, because if he disagrees with the governor, or if the governor disagrees with him, only with respect to the WAPA board, The only recourse the governor has is to dismiss him from his position altogether, because a director of the energy office has to sit in that position. And when the governor is forced to remove him from his position altogether, that in and of itself is a violation of the separation of powers doctrine by itself. Then when you couple into it, from a practical standpoint, the availability of these other individuals who are versed in finance, in engineering, and public works.
I don't buy that. You know, the legislation provides the expertise of who was to be appointed, and the governor can appoint a commissioner who has no absolute experience in those things and be a commissioner under the old section. Okay, thank you. You've actually gone over 23 minutes. Okay. I'm almost.
One last thing, Councillor. Remember,
I'm tempted to take away your rebuttal time, you know, because you. Cardi? Just the mic so it's.
Morning. Chief Justice, Associate Justice Cabret, Associate Justice Swan. May it please the court. For the record, I am Amos W. Cardi Jr., and I am the Chief Legal Counsel to the Legislature of the Virgin Islands. And I'd like to point out for the court's record that present in the courtroom this morning with me is the President of the 35th Legislature of the Virgin Islands, the Honorable Novell E. Francis Jr. I'd like to comment and respond specifically to some points that the court has raised with respect to the governor's argument as it relates to Act 8472. First of all, Act 8472 does not designate the Director of Energy by statute to be the chairman of the WAPA board. As a matter of fact, the Act is very specific. It says that there is hereby created a body corporate and politic constituting a public corporation and autonomous government and instrumentality of the government of the Virgin Islands by the name of the Virgin Islands Water and Power Authority, which shall be governed by a board consisting of the Director of the Virgin Islands Energy Office and 6 non-governmental members who shall be appointed by the governor with advice and consent of the legislature. So it is the board of the Water and Power Authority, the governing board, who chose the current occupant or the current director of the Energy Office to be the chairman. And this speaks to something that Justice Swan alluded to. It is the board is who governs the authority, not the governor. Even though this court has opined that, in this case, the Virgin Islands Water and Power Authority is a part of the executive branch, the distinction, however, is that it is not an executive department. And that is the nuance that the governor is missing. Even though WAPA may be part of the executive branch, it is not an executive department. That is important because the governor may remove the head of an executive department because they serve at the pleasure of the governor. That is clearly in the law. That is clearly a canon of the Constitution, the Organic Act, and so forth. However, the governor may not control the board of WAPA. The governor may not control the Virgin Islands Water and Power Authority. Even though it is an executive branch, it is created as an autonomous entity of the government of the Virgin Islands, not a department of the government of the Virgin Islands. And again, that is a distinction that the governor is conflated. He's conflating executive branch versus executive department. In addition to which, the fact is that the legislature is in Act 8472 requiring specific expertise to serve on the board. This is no different than other enactments of the legislature. For instance, in Act 8452, which I would note for the court, was passed on the same day, May 7, 2021, as Act 8472, the legislature established expertise for the Public Services Commission that their members have certain specific qualifications and expertise, no different than Act 8472. I would also point out to the court that Act 8452 was signed into law by the governor. That was not vetoed. Furthermore, the comment with respect to the argument with respect to the certain commissioners have expertise and they go before the legislature with that expertise, I would point out to the court that it is of public knowledge that the current commissioner of the Department of Public Works is not an engineer. As a matter of fact, it was stated in the public record that he was chosen by the governor because he is a manager, a good manager. He does not have an engineering degree. So we have a manager now, which is the governor's right to do, who is running the Department of Public Works. And historically, that department was run by an engineer. Furthermore, that same session of the legislature, May 7th.
The board can select any one of its members to be the chair.
That is correct.
Doesn't have to be only the director of energy.
That is correct. And the legislature recognized that because it did not statutorily say that the director of energy must be the chairman of the WAPA board. And that is in Act 8472. In addition to which, the fact that cabinet members, the governor makes the argument that the fact that the legislature appoints or is designating cabinet members to a specific board is usurping the governor's appointment authority, well, then the fact of the matter remains, we have right now in the Virgin Islands Port Authority, the statute specifically designates 3 members of the governor's cabinet, which are the Attorney General, the Commissioner of the Department of Public Works, and the Commissioner of Tourism. The statute specifically outlines them as members of the governing board of the Virgin Islands Port Authority. So there is clearly, there's nothing that is unusual about the legislature specifically designating which cabinet member would serve on a board, or in some cases giving the governor the option to determine which cabinet members serve on a board. And as the lower court pointed out in this case, that there is no, at least based on their research, there's no state that they were able to locate that found where it is a requirement that a cabinet member be on a district governing board. So the legislature may determine tomorrow that for the WAPA board or any other autonomous board, that there would be no more cabinet members. That is not an impermissible exercise of legislative authority. And I would also point out that in the same session of May 7, 2021, the legislature, pursuant to the enactment of Act 8445, which was, again, was signed into law by the governor, the legislature limited the amount of boards to no more than 2 that cabinet members may sit on because of the complaint that cabinet members, because of their responsibilities running their departments, oftentimes may not have the time to be able to sit on multiple government boards of agencies, autonomous entities, and so forth. So the legislature, in that same session when Act 8472 was passed, they limited the amount of boards, no more than 2, that cabinet members can serve.
What's that act number?
Act 8445. And I would commend that to the court's consideration as Act 8452, which I referred to earlier with respect to minimum qualifications for the Public Services Commission. So because WAPA is an autonomous entity, not an executive department of the government of the Virgin Islands, any change in WAPA's structure cannot impermissibly impede on the governor's ability to carry out his functions. Now, Act 8472 is a valid and permissible exercise of legislative authority pursuant to Section 8A of the Revised Organic Act, and pursuant to that act, which is where the legislature created WAPA, the 5th legislature, I would add, in 1964 as an autonomous entity of the Virgin Islands. And pursuant to Section C of the Revised Organic Act, the legislature has the authority to alter, modify, or amend any law that it passes to the extent that it does not violate any law of the Virgin Islands or of the United States. And it did so. Subsequent to the passage, the original enabling statute in 1964, it was then amended in 1968. It was subsequently amended in 1978, and then most recently before Act 8472 in 1984. And to Justice Cabret's question, that is when it was added in the provision that it provided for the removal for cause of non-government members of the board. So that is nothing new. That existed, and this court did recognize that point in its opinion denying the government's motion for a stay of this.
The government is arguing that because of Celia or Celia Law, LLC, that those for cause provisions are inorganic and unconstitutional, based on the Celia Law case.
So in reviewing that case, I think there are two things to consider. Number one, under Section 11 of the Organic Act, the Revised Organic Act, the governor of the Virgin Islands does have general supervision of the executive departments and agencies of the executive branch. However, there is a limit to that authority. It says, except as otherwise provided in the Revised Organic Act of 1954 or any other act of Congress under the laws of the Virgin Islands, right? With respect to the case that is cited, that involved an officer, a federal officer. There is no limitation with respect. There's no limitation that exists, I believe, under Article 2 of the Constitution on the president that there is on the governor under Section 11 of the Revised Organic Act. And I believe that this court has also made that distinction. So the governor's reliance on Celia Law, I believe, is misplaced.
The other distinction is also that WAPA is a multi-member board.
Correct.
Whereas the officer in Celia Law was a single member head.
That is correct.
And historically, multi-member boards have, the courts have allowed for-cause provisions where multi-member boards are concerned.
That's correct. And so, as has been pointed out in this argument, plus in the court decisions, the fact that there is a for-cause provision is something that is recognized, is something that is allowable, and the legislature of the Virgin Islands in 1984 did recognize that and included that in the WAPA statute. And the 34th legislature, in passing Act number 8472, did not disturb that. It was left alone. And that was the distinction that was drawn by the lower court in deciding this case before this court. Government Hospitals and Health Facilities Corporation, where the legislature removed the for-cause provision that was existing in, I believe, the original enabling statute of Act 60-12. So that is clearly a distinction. The other point that I wanted to make very quickly is that Act 8472 does not violate Section 16 of the Revised Organic Act. Specifically, that Section 16 of the Revised Organic Act, and it was referred to earlier, is the only provision that confers the powers of appointment and removal upon the governor. It confers upon the governor the authority to select heads of executive agencies that are named in Section 16 with the advice and consent of the legislature. All other instances with respect to the power of the governor has been conferred by virtue of laws passed by the legislature, including the enabling statute that is before this body. Establishes the Virgin Islands Water and Power Authority. And as the lower court pointed out, the legislature has the power to take away by statute, which has been given by statute, except when to do so would amount to an impairment of a vested right, which is not the case here. Now, as we have said, and as the record is very clear, Act 8472 simply reduced the membership of the WAPA board from 9 to 7 and left the cabinet member, the Director of Energy Office, as the only cabinet member on the board, right? And the other 6 members, as we've stated, may be removed from the governor for cause. So in reality, the governor, I believe the Chief Justice pointed out previously, he has the power to appoint all the members of the board. The cabinet member, which is the director of the Energy Office, and if the governor chooses in some future time, or the legislature chooses in some future time, director of the Energy Office should not be the cabinet member that should be sitting on the WAPA board, they may amend the statute. The governor may send an amendment by statute to the amendment to the legislature for their consideration, or the legislature themselves may amend the statute. And the other 6 members are appointed by the governor. So the fact that the governor may remove a member by cause only, again, does not impede, impermissibly impede on his ability to carry out his functions. Again, and I think it's very important that the record be clear, WAPA is not an executive department, even though it may lie in the executive branch. It is an autonomous entity of the government of the Virgin Islands that is governed by a board, and that board governs and set policies for the administration, management of the authority, not the governor of the Virgin Islands.
That's what I've been saying all along.
And
That's
this,
exactly what I've been saying all along. As a matter of fact, the last point that I didn't make was that when I was talking about where does WAPA gets its money from, you know, I might have made it clear, but for all intents and purposes, it's from the rates. It doesn't have to submit its budget to the governor. It's submitted to the board. The executive director and his financial people prepare the budget for WAPA and they send it to the board for approval. That's not to say that from time to time the legislature and the governor doesn't find money to help out WAPA, but WAPA depends on the bond issues, and they don't have to get the governor's authority to issue those bonds, and they have to go before the Public Service Commission to get their rate if they want a rate increase. I better not talk too loud about rate increase because I don't want anybody to go and try to seek another one. But for all intents and purposes, that's what it's all about. And this thing has to look at the totality of this thing as to WAPA. WAPA is a creature that was created as very, very long ago, and it was given, except maybe to the Port Authority that might be rivaling it in terms of independence. But when you read that statute of all the power and authority that WAPA has, starting with sue and be sued, and autonomous instrumentality, can enter into contracts, can do all of these things. None of the other 9 organized department of the government in the executive branch come remotely close to having the power that WAPA has. So I don't know. I think it's a failure to recognize that WAPA, you got to start with the premises, WAPA is not an executive branch department, an executive branch board. And if you miss that point, then you have all this conundrum of confusion and chaos when there's a refusal to recognize WAPA for what WAPA is according to the statute. An independent instrumentality, governmental in nature, but it's controlled by a policy-making board and an executive director.
and the court, the lower court and other courts have recognized that WAPA has a personality separate and apart from the government of the Virgin Islands because it is autonomous in the sense, from a financial sense, to be able, not only from its governance, to be able to generate its own revenue. Water production, power production, and I believe Justice Swan, you spoke with respect to rates. It is not designed to rely on the government. WAPA's budget, unlike an executive branch department, or, I would add, a semi-autonomous entity of the government of the Virgin Islands, such as a hospital corporations, WAPA's budget is not included in the executive branch budget of the government of the Virgin Islands. It is designed to generate its own
The budget that
revenues.
he submits to the legislature.
There's no submission of the budget from to the legislature by the Virgin Islands Water and Power Authority because of obviously recent intervening events, the government has had to support WAPA as is my understanding, and in the public record, to the amount of almost $4 million per month. But that was not the way in which the legislature, when it created WAPA, intended for WAPA to be operated.
That's the same point I was saying, that we cannot afford for WAPA to fail because it would be catastrophic for all of the residents and all of the people of the Virgin Islands, including the hospital and everything. We have to keep WAPA running, whether by solar or otherwise. But the fact that it might come hand in hand and beg the executive branch and the legislature for money does not mean that it loses its independence as to what was created as an autonomous instrumentality. And it goes on to say what? Separate and apart.
That is correct.
From the government of the Virgin Islands. Separate and apart. You can't
Please
want
conclude.
better than that.
In my argument, it is on behalf of the legislature of the Virgin Islands, we would respectfully request that this court find that Act 8472 to be a valid and permissible authority of exercise of legislative authority under sections 8A and section 16 of the Revised Organic Act, and find that it is constitutional. Thank you.
Thank you. Attorney Clement, yeah. Is WAPA, are you representing both?
No, just the governor.
The WAPA did not wish to argue?
The supplemental order that you sent out did not provide for WAPA to have an argument. You stated they had
We didn't
rendered because they agreed with us.
agree, but didn't it also say that you could share with WAPA?
Not going to argue today. So I just want to be really brief, and appellants do not quarrel with the educational and experience requirements. So if the commissioner of the director of the Department of Public Works does not meet that requirement, I'm not saying that he doesn't, then he would not be able to serve. So whatever cabinet member that the governor selects, that person has to meet those requirements, and that's provided under the Revised Organic Act. The legislature can prescribe the rights and duties of the members. We don't quarrel with that. But we have to separate what is theoretical from
If you appoint a director of
what
energy,
is
isn't that
reality.
indicate that that's a person that's has to be familiar with WAPA's operation, which is creating energy?
Yes.
You're saying it doesn't have to be, the governor's representative does not have to, he or she has to meet, which requirement does the law require that person to meet?
Well, it specifically says that one of the members of the board will be from the energy office. So, I mean, you would assume that he meets both the experience and the educational requirement, but that person is specifically designated.
But the legislation assumed that the director of energy is going to have some familiarity with energy.
Right. We're not. All right. So we're not quarreling with that. But what we're saying is, when that person is the only person, and they specifically direct that person to be the only person from the cabinet, and you remove two individuals from the cabinet. See, previously the governor had
Couldn't the
this choice
legislature
of
have
three.
removed all three?
Pardon?
Couldn't the legislature have removed all three of the governor's commissioners?
Directly, they could have. We'd be making
So
a different argument.
why is it to be faulted since it left one?
Well, as a practical matter, the problem here, and the quarrel is not with that individual person. I mean, there is a quarrel with that, but it's a separate issue as to the removal of cabinet members and then the other 6 only being removed for cause. And when you couple all that together, it does constrain the oversight of the supervision of the board. And while WAPA is autonomous, it is not private. And as a practical matter, it does depend upon the government. You take, for example, the lead water crisis in St.
What
Croix.
does that have to do with construing the statute, whether or not it violates the separation of powers?
Because
You're talking about a board for a public corporation, so to speak. What difference it makes? I don't understand your argument, to tell you the truth. I mean, I don't see it as a constitutional argument. You know, you might not like the fact that the governor, energy director has to be on the board, and if the governor don't want him on the board, then he would have to dismiss him. But other than that, and even that, since you have the Port Authority that has 3 designated members by name, just like in this case, you have the Attorney General, you have Public Works, and you have Tourism. Those are listed by name. In this case, there's one, and is listed by the office. So I don't see the difference.
well,
Are you saying then that WAPA, the Port Authority Board, is illegally constituted by naming
we're not,
specific commissioners?
no, we're not saying that. In fact, this board itself had named commissioners in the past. We're not saying that, but what we're saying is that here, in this particular instance, when you couple the fact of the naming of the Director of the Energy Office, and then you couple the removal of 2 cabinet post members from the board, and then you couple the fact of the 6 remaining people being only removed because it does place an undue burden on the governor's ability to manage and supervise the board. And while, yes,
But that's not the test. The test that has to be implemented is whether or not the governor is prevented, not whether it's an undue burden. And I think that's what the government has failed to show. How is the governor prevented in his responsibility to take care of the laws, to make sure that the laws are enforced? I mean, where does the prevention come in?
well, the governor is prevented because, as a practical matter, you have to have people who are responsive on the board, and I will point again to the St. John underwater cable incident. You have to have people who are there who are going to meet a
Do
quorum.
you think
And so
the law should be crafted because of one incident where they weren't able to make a quorum? I mean, that is what determines whether a law is sound or not. Because I keep telling you that under this situation, you wouldn't have to find a 5th person to make a quorum. You would have 4. So this makes it easier to make a quorum. So that argument kind of escapes me. Okay, if there's nothing else, you want to make a closing statement before you leave?
the government will rest on its brief, and we still maintain that Act 8472 violates the separation of powers doctrine, and we ask that this court so find.
Thank you. The matter is submitted. And with that, that concludes our business today, so motion.
One, please rise. Honorable court now stands adjourned. Please remain